Morning, everyone. The Senate Judiciary Committee will come to order. Thank you for standing by. We were waiting for a report that needed to be signed for other business in the legislature. So want to welcome everyone today, and we will get started right away. We have a busy day today. We will open then the hearing on House Bill 2227. If we could have the reviser give us the bill brief. Thank you.
Thank you, Madam Chair. Good morning, committee. Jason Thompson with the reviser of statutes. House Bill 2227, as amended by the House Committee, allows the Chief Justice of the Supreme Court to suspend certain time limitations during a state of local disaster emergency, suspend certain verification requirements, and authorize use of electronic audiovisual communication to expeditiously resolve cases. It also extends the Chief Justice's authority to suspend time limitations during a disaster emergency until June 30th of 2022. So the bill amends KSA 20-172. Current law there in subsection A allows the Chief Justice to issue an order to extend or suspend certain time limitations during a state of disaster emergency under 48-924. The bill gives the Chief Justice that same authority during a local disaster emergency that might be declared pursuant to 48-932. Those of you that are familiar with the KEMA discussions we've been having recognize there are two different kinds of declarations, and this would cover both the state declaration or a local declaration. The bill also allows the Chief Justice to issue an order to suspend the verification of an appeal required pursuant to KSA 38-2273. That's part of our revised child in need of care code during these same disaster emergencies. So that's an additional change, not in current law. Also in current law, subsection C, any order issued under subsection A may remain in effect for up to 150 days after the disaster emergency is terminated. The House Committee on Judiciary added a new subsection D to clarify what occurs when those orders under subsection A terminate. So for deadlines or time limitations extended or suspended because of an order, on the date the order terminates, the person shall have the same number of days to comply with the deadline or time limitation as the person had when the deadline or time limitation was extended or suspended. So if you're if it was suspended or extended and it was already going, you have the same number of days you had before. And then for deadlines or time limitations that did not begin to run, so they had not started yet, when the order terminates, the person has the full period provided by law to comply with the deadline. So there's two different scenarios there, depending on whether it had started or not started when it was suspended or extended. Finally, I'll note a couple things in current law. Subsection B allows the Chief Justice to issue an order to authorize that two-way electronic audiovisual communication in court proceedings. The bill gives the Chief Justice that same authority that's already there. But when the Chief Justice determines such action is necessary to expeditiously resolve pending cases. So that is an addition. And finally, the sunset on the bill is March 31st of 2021, of the current statute. The bill would extend that to June 30th of 2022. And furthermore, the sunset would not apply to subsection B. So the provision about audiovisual communication for any hearings would apply without a sunset, but the other provisions related to time limitations would expire on June 30 of 2022. And with that, I'll stand for questions.
Thank you, Mr. Thompson. Committee, questions for the reviser? Senator Gossage.
Thank you, Madam Chair. This is just a technical question. Could you explain the, I understand italics, but explain the bold?
Yes, Mr. Thompson.
Thank you, Madam Chair. So in the bill, we have certain fonts required by statute that are used to denote when amendments were made. You're used to seeing the as introduced version of a bill, where it's just standard fonts with italics for changes. So the regular font is for current law, and then the italics is the change in law. So then when you have an amendment, say by the House Committee in this case, it gets the bold font. And if you have an amendment on the House Committee of the Whole, it gets a bold italic font. So as you see these bills come over from the House that have amendments, you'll see these fonts more and more. So thank you for asking. And yes, that means those were added by the House Committee. if it's in bold.
Thank you, committee. Any other questions? All right, seeing none then, we will invite our first proponent conferee to the podium, Sean Jurgensen, Special Counsel to Chief Justice Marla Lugert, and he is appearing by WebEx. So please introduce yourself and welcome back to committee.
Good morning, Chairwoman Warren. Can you hear me?
Yes, we can. Thank you.
Thank you, Madam Chair. Members of the committee, I'm Sean Jurgensen with the Kansas Judicial Branch. Thank you for allowing me to appear today as a proponent conferee to discuss House Bill 2227. Like Jason just mentioned, the bill would amend 2172 governing the Chief Justice's emergency powers. And I don't have a lot to add of what is currently codified in the statute on what the Chief Justice is allowed to do. And I know that we covered a lot of that ground during our presentation before Senate Judiciary a couple of weeks ago. And Madam Chair, like I mentioned at the presentation on February 23rd, when we discussed the judicial branch's plan to respond to the current emergency, this authority expires March 31st, but it's critical to the judicial branch's ability to respond to the pandemic and implement the response plan it has crafted. And so, and I know that Jason covered these, but the bill would codify a handful of changes to the statute. First, it would expand the relevant emergency provision, authorizing the Chief Justice to suspend or extend the permitted deadlines and time limits under a local disaster declaration, in addition to the state of disaster emergency. And so while currently the Chief Justice may suspend statutory time limits and deadlines when a state of disaster emergency is in effect, allowing suspension of time limits or deadlines during the local disaster declaration would provide Kansans and the judicial branch greater flexibility in responding to an emergency. It permits a suspension order to be entered when a local authority, whether it be the chair of the county commission, a mayor, or the otherwise a principal executive of a municipality, or a majority of the governing body in their absence, as the case may be, when they've issued a local disaster declaration. And by doing that, it allows the judicial branch to tailor its operations and response to an emergency that may manifest only locally. So think possibly a courthouse fire or a physical or cyber attack on a local entity, or frankly, another act of God like the pandemic we're experiencing currently. And so that's the first change that it would affect. The second, the bill would grant the Chief Justice authority to suspend the verification requirement under 382273 during a disaster emergency or a local disaster emergency when it's necessary to secure the health and safety of court users, staff, and judges. And so this concerns appeals taken under the revised Code for the Care of Children from an order of temporary custody, adjudication, finding of unfitness, termination of parental rights, et cetera. And in those appeals, Madam Chair, every notice of appeal, docketing statement, or brief must be verified by the appellant if that appellant has been served personally during the course of the proceedings. And failure of the appellant to verify those pleadings results in dismissal of the appeal. But during COVID, when the appellant is incarcerated, the party and counsel's ability to comply with the requirement has been difficult. And because this involves some of our most vulnerable Kansans, children who've been adjudged in need of care, we propose authorization allowing the Chief Justice only when necessary to secure the health and safety of everyone during a disaster declaration, to permit those appeals to proceed timely by suspending the verification requirement. And the record on appeal will still exist. It's just simply the verification requirement that would be suspended. And so that's the second thing that the bill would do. Third, it would add expeditiously resolve pending cases as a permitted rationale in eliminating the sunsets application and authorizing the use of electronic audio-visual communication in court proceedings. And this is absolutely integral to our operations statewide. Without the authorization for continued use of AVC in court proceedings, it would cripple the judicial branch's ability to currently operate. Tens of thousands of remote proceedings, Madam Chair, have occurred during the pandemic. It's a tool that we've been utilizing during this period of the pandemic. For example, like the Chief Justice mentioned in her State of the Judiciary, Johnson County, at the time that the State of the Judiciary was released, it had conducted about 67,000 remote hearings, while when Chief Judge Brown appeared a couple of weeks ago from Hayes, he had mentioned that they had conducted approximately 4,700 virtual hearings. And it's not just in Kansas for the committee, it's happening nationally. And so extending that authorization permits us to continue fully functioning during the pandemic, and it maintains our increased capacity. As we've discussed, the court system today faces a higher jury trial caseload than it has in recent memory. And in-person proceedings, no matter the type, are required to comply with health and safety protocols, which includes convening in an appropriately outfitted courtroom. And we only have so many of those courtrooms. And in my opinion, I would rather those courtrooms be used for proceedings that are required to be conducted in person. But for those proceedings that can occur remotely, I think Kansas is better served not tying up those COVID-ready courtrooms on matters that could have been resolved remotely. I think doing otherwise would artificially slow down the process. ABC has also increased our appearance rates statewide. Individuals appearing in court no longer have to take a day off of work. They can simply take a break, go to their car and appear remotely, then return to work. And that convenience has dropped non-appearance rates, which frees up more court time as you're not juggling multiple settings on the same matter. Allowing the use of ABC has saved a lot of money. I'm told that in Johnson County alone, they're expected to save significant sums of money just on transporting fewer inmates from the county jail to the county courthouse for scheduling hearings or other routine hearings. And not only that, it's saving critical criminal defense resources as windshield time amongst the criminal defense bar is decreased, as well as the practice of law across the board. And finally, I suppose we have the infrastructure now. We were able to use federal COVID grant money to purchase the infrastructure. And so hopefully it's a tool we can continue to use moving forward now that we have that infrastructure in place. Finally, like Senator Gossage was mentioning with Jason, the language that was added in the balloon amendment in the House Judiciary Committee, it provides for the computation of time upon termination of the suspension order. So it occurred to us that it'd be best if we had some language in the statute that provided for the computation of time when the suspension order is lifted. And so the language you see in D1 and D2 treats the calculation essentially like a pause button would. So for instance, if you had 10 days left before your deadline ran, when the suspension order was entered, when the suspension order is lifted, you'd still have 10 days before you had to meet your deadline. And for those deadlines that the clock never started ticking for because of an existing suspension order, upon termination of that suspension order, the clock would start and you'd have the full period of time as provided by law. And then finally, the bill would extend the sunset on the law by 15 months until June 30th of 22. And so, Madam Chair and members of the committee, I know that our deadline is quickly approaching March 31st, so I sincerely request that the committee recommend this measure favorably for passage. Thank you, Madam Chair, and I can stand for questions at the appropriate time.
Thank you. We'll take all questions after both of our proponent conferees. We'll next then welcome Nick St. Peter, Chief Judge, 19th Judicial District, who's appearing by WebEx. So please go ahead and introduce yourself and welcome to committee.
Thank you, Chairwoman Warren and members of the committee for giving me the opportunity to address you this morning. My name is Nick St. Peter. I'm the Chief Judge of the 19th Judicial District, which happens to be the smallest judicial district in Kansas, which is comprised of Cali County. Just to give you a little bit more background, I also have been serving as the chair of the Virtual Court Proceedings Committee, which was organized by the Kansas Supreme Court to look at both standards, guidelines for the use of virtual court technology, both now and in the future. In our judicial district, we have no magistrates. So while I'm the chief judge, I hear cases all the way from speeding to murder, small claims to complex civil litigation, juvenile sink, preside over a problem-solving court and have since 2009. So I've had quite a variety of experience in various areas of the law to utilize this technology. I've been on the bench almost 17 years. This time last year, the judicial branch, as well as all members of society, took a huge shock when the pandemic began, and we had to adapt quickly to continue to operate. And the judicial branch, through the authority that was granted to the Chief Justice, responded to that and began doing hearings remotely. That allowed us to essentially get caught up on our work and operate our dockets in what I call real time. In other words, after about 2 months of the pandemic, at least our district was operating in real time, hearing cases and dockets through this technology, just like we did before, except the appearances were through this technology and not in person. What I would submit to you today is that this technology has become such a huge part of how we operate our court system. Attorneys and litigants have gotten used to this technology. If we were to lose the ability to do this on March 31st, it would create an equally dramatic shock to our system. Tomorrow morning, for example, I will have 40 cases on my docket with attorneys, all of which will be done remotely, all of which every attorney and every litigant had the opportunity to say, I would rather appear in person, all of which declined to appear in person and would prefer the convenience of appearing remotely. Tomorrow, I'll do a settlement conference in a civil malpractice case where the attorneys from out of town will appear remotely for what will amount to a 10-minute hearing. Otherwise, they would be driving here out of their office, charging their clients money to appear. We've seen a dramatic decrease in the attorney's fees that we've been paying out in our county for court-appointed attorney's fees, simply because we're not having to pay the windshield time. We're not having to pay mileage for all of these court appearances. So what has started off as really a matter of a must to function has really turned into a matter of convenience for the citizens of the state of Kansas. And as I indicated, to lose the ability to do this now would create an equal shock to our system and would put us back in a position of having clogged dockets again, simply because of the amount of work and staff time it takes to have people in our courtrooms. This morning, I conducted an in-person preliminary hearing before I came on to this WebEx hearing. We had 3 witnesses testify. I had to get off the bench and go and clean the witness stand in between every witness, allow that to dry. I had to go through and clean our courtroom where counsel were at the time after the hearing, so that it'd be prepared for the next in-person hearing. That's not probably going to change anytime in the immediate future. It takes substantial time, not only for judges, but staff to do that. And if we had to begin bringing people back into our courtrooms beginning April 1st, it would be a shock to our system that we just are not really prepared to deal with at this time. And it would not, at least in my view, be in the interest of the citizens of the state of Kansas. This technology, I don't think anybody would want to see it go away at this point. However, it does have limitations. And we need to continue to use this technology and study its impact on both the quantity in terms of access to justice and quality of justice to the citizens to determine the parameters of how this will be used. To do that, we need to continue to be able to utilize this technology. So for these reasons and the reasons as set out in my written testimony, you can see our committee has created some guidelines that we recommended to the Supreme Court, which they've adopted in order to create structure to how these matters are how this technology is utilized. Those will continue to probably be refined as we move forward with the use of this technology. So with that, I would ask that you support the extension of time for the use of this technology so that our court system can continue to operate and not undergo a second shock that would impact our ability to maintain the dockets that we are working at this time. Thank you very much.
Thank you. Committee, you'll see that we have proponent written testimony in your committee folder from Glenn Braun, Chief Judge, 23rd Judicial District, Joseph Molina, Kansas Bar Association, Callie Denton, Kansas Trial Lawyers Association, and Amanda Stanley, Kansas League of Municipalities. With that, then, we will open it up for questions from the committee to the conferees. Seeing none, I do have a question for the reviser, probably. I know that when we were looking at this in House Bill 2016, we wanted to make sure that there were in-person evidence in criminal proceedings. Is that still the current law to protect your constitutional right to confront the witnesses against you in a criminal case, that you can't use audiovisual technology to accept evidence in a criminal case? Is that where we are in the current law, Mr. Thompson?
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. My recollection from the discussion in the speedy trial bills and in the other context is that you still have your constitutional right to confrontation under the Sixth Amendment, just like you have your right to the jury trial. And I think that's how the court is operating right now. I will defer to some conferees if they have any input on that as well, since they're out in the field doing it, but that was my understanding.
Thank you. Then for the conferees, is there, I know in the bill, House Bill 2227, on line 20 of page 1, it says, notwithstanding any other provisions of law. Have the courts recognized that those other provisions of law that we need to preserve the constitutional right to confront the witnesses against you, particularly in the criminal context, so that we're taking evidence in the court in a criminal proceeding, not through audiovisual technology?
I'll be happy to address that.
If you'll identify yourself first again for those following along. Thanks.
Thank you. I'm not used to this, so this is new for me. Thank you. Nick St. Peter, Chief Judge, 19th Judicial District. Yes, the time standard, the suspension of time standards in the use of audio-video technology does not change the constitutional rights that any individual has with respect to a court proceeding. We still do in-person proceedings where the right to confrontation does apply, and unless the parties all agree, including the defendant, to proceed in a manner inconsistent with that.
Right, that right can be waived by the defendant if they so choose. So I just wanted to make sure that we weren't interfering with your constitutional right, especially in the criminal context, to confront the witnesses against you. And so I would, I guess, ask Natalie Nelson, our researcher, or the reviser, to make sure that in other areas of law. I know, of course, there's the Constitution. Whether in statute, though, we've made it so that those rights are preserved as well. But I think I have the question answered then. Thank you, Judge. Other questions from the committee for the conferees? Seeing none, then we'll ask if there are any other proponent conferees on House Bill 2227 in the committee meeting room or on WebEx. Seeing and hearing none, are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, any opponent conferees in the committee meeting room or on WebEx? Seeing then none, I want to thank our conferees. Judge, thank you for appearing in committee this morning. Appreciate it. Nice to meet you on WebEx and maybe some other time in person. Thank you for the work you're doing in your courtrooms, and thank you to Mr. Jurgensen appearing as well in committee today. Appreciate your time. With that, then, committee, we will close the hearing on House Bill 2227 and open the hearing on House Bill 2126. We will start with a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the reviser again. House Bill 2126 also comes to you as amended by House Committee. It provides immunity from civil liability for COVID-19 claims for certain covered facilities, including adult care homes, community mental health centers, crisis intervention centers, community service providers, and community developmental disability organizations. You will recall that your current law adopted in last session in KSA 60-5502 and 60-5506, those are part of the COVID-19 Response and Reopening for Business Liability Protection Act. Those statutes provide that an adult care facility, which is currently defined as a nursing facility, assisted living facility, or residential healthcare facility, they have an affirmative defense to liability in a civil action for a COVID-19 claim if that facility was acting in substantial compliance with public health directives and was either required by law to re-accept a resident who had been removed for treatment of COVID-19 or treated a resident who was tested positive for COVID-19 in compliance with law. So it's a narrowly tailored affirmative defense that applies in those circumstances I just described. The bill amends 60-5502 to expand that definition of adult care facility to now include an adult care home as defined in 39-923, include a center approved by the Centers for Medicare and Medicaid Services as a program for all-inclusive care for the elderly, that's known as PACE, that provides services only to PACE participants. And then the House Committee on Judiciary further added amendments to expand that definition to what we now just call the term covered facility. And it would include a community mental health center, a crisis intervention center, as defined in 39-2002, and also a community service provider, a community developmental disability organization, and an institution as those are defined in 39-1803. The bill as amended by the House Committee also amends 60-5506 to provide that these facilities are immune from liability for a COVID-19 claim. So not an affirmative defense, but immunity from liability like other provisions in that reopening act that you passed. And they're immune if such facility was in substantial compliance with public health directives applicable to the activity giving rise to the cause of action when the cause of action accrued. That language is fairly similar to the business liability provision you may recall discussing earlier in the session and that you adopted last session. Public health directives is narrowly defined to mean any of the following that are required by law to be followed related to COVID-19. One, state statutes or rules and regulations, or two, federal statutes or regulations from federal agencies, including the CDC and the Prevention and Occupational Safety and Health Administration of the U.S. Department of Labor. So not any other law other than those specifically mentioned. The immunity does not apply in cases of gross negligence or willful, wanton, or reckless conduct. Again, similar provision to what's in the business liability section. Finally, the bill amends KSA 60-5508 to provide that the amendments made to the two sections I've mentioned, 5506, apply retroactively to any cause of action accruing on or after March 12th of 2020. That was when the disaster emergency was declared, and it applies through the end of the state of disaster emergency related to COVID-19. And this would become effective on publication in the registry if it is adopted. Now we stand for questions.
Mr. Thompson. Committee questions. Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Thompson. Some of these things are running together in my mind, Madam Chair. I can't keep them all. Mr. Thompson, haven't we discussed this in some form or another, that being the liability conferred to these adult care homes and some other provision, maybe the KEMA provision, this particular plank? I mean, this year, it seems like even within the last few weeks, but have not we had a discussion in this committee regarding these provisions in some other form?
Mr. Thompson, go ahead.
Thank you, Madam Chair. Jason Thompson again. There have been a lot of discussions about this particular issue, but the only bill I recall hearing in this committee was regarding the business liability provision, which I referenced a couple times. That was, of course, Senate Bill 283 that this committee worked on. And it had some similar mechanics where you were attempting to clarify the retroactivity of that provision, and you were trying to make sure it had the same exclusions about wanton and reckless conduct, et cetera. But I don't believe we've actually addressed the affirmative defense or the adult care facility immunity issue yet in a bill in this committee, just the business liability portion. But that may be why it sounds familiar.
It does, and thank you, Madam Chair. Mr. Thompson, are we defining, I didn't see it in the bill that I have, where willful, wanton, gross negligence, are those definitions found where they could be shown for what level must be reached? I don't see the definitions, of course, in 2126. But is there some other statute that could be easily referenced to show where these adult care homes meet that test, where the definitions are in statute?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the reviser again. You're correct. There is no definition of gross negligence, willful, wanton, or reckless conduct. And I hope that you don't ask me to do that. There is abundant case law regarding those issues, and I believe that's why they're not defined. They're terms of art that have a specific legal meaning, and they would be determined on the facts of the case. You would bring, in theory, you would bring your action, and the person claiming immunity would say, this does not fall under, or this falls under the immunity provision, and your action is not allowed. And your response might be, it actually does not apply. The immunity provision does not apply because this action was gross negligence, or this action was willful, wanton, or reckless conduct. And then you have a dispute, and you try that, you find that issue out as part of the case or controversy in front of the court. So,
thank you, sir, and thank you, Madam Chair.
Other questions for the reviser? One quick question. Without House Bill 2126, are these type of facilities provided any protection from COVID-19 claims like other businesses are?
Thank you, Madam Chair. Jason Thompson with the reviser again. That's sort of a loaded question, and I know you don't mean it to be, but as you all know, this is a very hot issue. I will simply say the statute you passed provides an affirmative defense. This provides an immunity. The differences between those, I think you'll hear some different opinions. And so I'll defer, if I may, to the conferees to kind of discuss the legal intricacies of that. But I will say the current law, you provided an affirmative defense, and this attempts to provide immunity and broaden that immunity to other entities that may not currently have an affirmative defense or immunity. Although there is some dispute about whether those entities are covered by different provisions currently. And so I don't want to go down that road too far either. So I apologize for trying to dodge the question, but I think you've got conferees that might address it better than I can from my nonpartisan, non-policy perspective.
Thank you. And where, oh, I see, is immune from liability. It's on lines 8 and 9 on page 3 of the bill. Okay, and committee, we do have 4 conferees signed up to be in person, or at least oral conferees, and I want to get them all in. I also want to be able to work House Bill 2227 today before we leave, before we adjourn. and possibly House Bill 2126 if we can. So for that reason, I'm going to give each conferee 4 minutes. If Mr. Vice Chair could be the timekeeper of the 4 minutes, and we will give you a signal when you have 1 minute remaining. And with that, then, we will invite our proponent conferee, Rachel Monger, Leading Age Kansas. So please introduce yourself and welcome to committee.
Is it on now? Okay, great. Thank you so much, Madam Chair. I am Rachel Monger with Leading Age Kansas, and we are the State Association for Nonprofit Long-Term Care in Kansas. I just wanted to quickly say that our members are very passionate about this issue, if you didn't know already. I think many of you do. And we do have written testimony from some of our providers. They weren't able to appear today. That just happens with providers sometimes, but I do hope you'll take the time to read those from them. So, again, just a quick description of who we're talking about for adult care homes, particularly in our membership. Our members are, as I said, not-for-profit. We make up half or more of the senior services being provided in Kansas. We have deep roots in our communities. Some of our providers have been around for over 100 years. They started as homes for widows and orphans when that was a thing, a century ago. We have some private nonprofits and government-owned. Most of them are faith-based, and they are all run by boards of directors made up of community leaders. Naturally, all of our members do provide nursing home care, but only a few have chosen to provide nursing home care only. Quick list, we have nursing homes in our membership. We also have assisted living, home plus, residential health care communities, continuing care retirement communities, senior housing, low-income senior housing, home health, home and community-based services, hospice, PACE, and Meals on Wheels. And I'm telling you this because the majority of our members, they serve in communities of less than 4,000 people. And so when we have harm that's caused to our providers or the loss of any one of our providers, it can have a really devastating effect on the communities and the elders that they serve. Now on to House Bill 2126. First, we always like to point out this bill does not shield bad actors from accountability. It does have liability protections that do not apply to acts, omissions, or decisions that result in gross negligence or willful and reckless conduct. And after amendment from the House, it also requires that the providers be in substantial compliance with public health directives. What it does do is provide protection for the 99.9% of senior care providers in the state that are doing their best to care for residents during an unprecedented public health emergency that has gone on for a year and counting. And as I wrote about in my written testimony, back in November 2020, the Associated Press worked with researchers from the University of Chicago to study nursing home outbreaks in 20 states, including Kansas. The researchers found that the quality of a nursing home was unrelated to the number of COVID-19 infections they experienced during the fall surge in nursing home outbreaks.
1 minute.
They found that the biggest factor in nursing home outbreaks was the degree of infection spread in the community, as well as the high number of asymptomatic carriers, nursing home staffing shortages, lack of access to timely testing and testing supplies, and shortages in personal protective equipment. And to be clear, these issues were not limited to early on in the pandemic. These were things going on in November and December and continue on to this day. We need House Bill 2126. Singling out long-term care for personal injury and class action lawsuits threatens the very existence of senior care in Kansas. It has already caused spikes in liability insurance markets and will become unsustainable very quickly. The affirmative defense for adult care homes in the existing liability statute is not sufficient protection. It is too narrowly drawn, and even if written broadly, an affirmative defense still requires expensive and time-consuming litigation. Immunity from COVID-19 related claims will ensure that such issues are addressed early on in the case and minimize the considerable financial and resource drain of unwarranted lawsuits. Thank you very much, Madam Chair.
Perfect. That was 4 minutes. Thank you very much. Appreciate your testimony. Committee, I will also direct you to your committee folder where we have proponent written testimony from Haley Bordoin from the Kansas Adult Care Executives Association, Audrey Dunkel, the Kansas Hospital Association, Jeremy Armstrong, Mitchell County Hospital Health Systems, Charlotte Rathke, Locust Grove Village, and Chris Erickson from Bethany Village. With that, then, I will ask, do we have any other proponent conferees in the committee meeting room or on WebEx?
Yes, ma'am.
Yes, okay. It looks like we have one in the committee meeting room and one on WebEx. So we'll go with the committee meeting room first. If you'll introduce yourself, and do you have written testimony as well?
Madam Chair, I do. My name's Mark Maloney with the Hinkle Law Firm.
Okay, and we'll 4 minutes then.
Thank you. As I said, members of the committee, I'm a practicing attorney with the Hinkle Law Firm and have been defending healthcare providers for almost 20 years. That includes the defense of long-term care and nursing home facilities. I'm here today on behalf of Progressive Healthcare Alliance, a group of small-town, faith-based nursing homes. I am currently defending 2 lawsuits in Sedgwick County District Court arising out of allegations of negligence when residents contracted the coronavirus in April and May 2020. I want to specifically address the difference between statutory immunity and the affirmative defense. From a legal perspective, I was able to utilize the bill passed last May to assert an affirmative defense. That cost my client in different ways, and those costs are different than if a statutory immunity had been available, is my belief. The cost to my clients is that I am boots on the ground in the facility, pulling staff away, forcing them to hire backup staff to provide care to those residents, while I ask them questions about what did you do in this unprecedented time of a worldwide pandemic to procure PPE? That's an acronym a lot of these CNAs and nurses had never even heard of before February and March of 2020. I asked them, who did they call? What efforts were made to analyze your infectious disease policies and protocols? Candidly, this was a time-intensive and labor-intensive effort as I began to mount my affirmative defense. I believe that the immunity provision that was afforded to other healthcare providers in the law passed in the special session should be applicable to nursing homes and long-term care facilities. That levels the playing field and is the right thing to do. Again, I want to emphasize the unprecedented nature of the coronavirus pandemic and the uncertainty that the
1 minute.
The uncertainty that this brought into the nursing home and long-term care environment. I support House Bill 2126 as amended and urge its passing. I'll stand for questions at the appropriate time.
Thank you. And we had someone on WebEx then who was a proponent conferee. If you could introduce yourself, please, and welcome to committee, and we'll have 4 minutes.
Thank you. I'm Linda Mowbray. I'm the President CEO of Kansas Healthcare Association and Kansas Center for Assisted Living. We are a trade association that represents both for-profit and not-for-profit long-term care services. Our members are skilled nursing facility, assisted living. We are also representing Home Plus, residential health care, state with our membership. I know that when House Bill 2016 was before you in the special committee, that you were between a rock and a hard place. I do understand that you had to make a choice that at the time seemed like it was for the greater good. The choice, as it turns out, left the long-term care profession with the affirmative defense to liability instead of an immunity. This is an opportunity with House Bill 2126 in its simplest form to change that, to right that wrong, and to allow those providers, those healthcare providers, to have the same, not more, but the same type of protection under the law. Our homes have seen an increase in liability insurance rates. They had limited access to PPE in the beginning. There was a disconnect between KDADS, KDH&E, staffing shortages, and as my colleague Rachel Monger had suggested, that it's more about how much COVID was in the community for the likelihood of having COVID come into the nursing home or the assisted living. There was a lot of misinformation and disconnect between state rules, federal rules, who was following what. Our facilities were in a crisis and they still remain in a crisis. You have my written testimony. I appreciate the time in front of you today. And I would simply say that now is a chance to right that wrong and give that immunity to liability to those providers that have been doing heroic work throughout the pandemic. I'll stand for questions at the appropriate time. Thank you.
Thank you very much. Do we have other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then. We don't have any neutral conferees signed up, but I'll ask, are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we will invite our first opponent conferee, Tom Wagstaff of the Kansas Trial Lawyers Association, who I believe is appearing on WebEx. Please introduce yourself and welcome to committee. 4 minutes.
Thank you, Madam Chair. Can you hear me okay?
Yes.
Great. My name is Tom Wagstaff, Jr. I appreciate the opportunity to talk to this committee today. I am an attorney in Overland Park, Kansas, and I have been handling, representing families and handling cases involving long-term care facilities for 20 plus years in the state of Kansas. I'm here to speak on behalf of the Kansas Trial Lawyers Association. And I want to just first say, I'm sorry, I'm not wearing a tie. I found out yesterday about this committee meeting, and I'm on vacation with my family and my kids. So I just want to, no disrespect. I'm sorry about that. Why is it important? Why is this issue important? Elderly Kansas residents who live in nursing homes have rights, rights such as dignity, rights such as respect, rights such as quality care. Elderly Kansas residents need to be kept safe and protected. Elderly Kansas residents are entitled to quality care, as I said. They're entitled to proper infection control procedures. Facilities across the state have policies and protocols on infection control, and they always have, and they always should have. Residents in these facilities have plans that deal with infection control, and they always have, and they will continue to going forward. These are quality measures that have been in place before the pandemic and will be in place after the pandemic. Infection control is important. These facilities that we're talking about, I do not think it can be overlooked. Nursing homes and long-term care facilities for these residents, for these elderly people, this is their home. This is where they live. It's not a 5-day hospital admission. These people wake up there, they go to bed there, they eat their meals there, they stay there. And in today's world, their sons and their daughters can't go see them most of the time. And so it's important that we keep the accountability piece so that these rules can be followed and implemented. Kansas Trial Lawyers Association, as a general principle, is opposed to immunity. The first reason why is accountability. With immunity, the accountability piece simply is not there. There's no enforcement mechanism to ensure that rules are followed. Immunity denies the constitutional right to trial by jury. And
One
no
minute
one
remaining.
is. Okay. Let me say that what is in place currently with House Bill 2016, it provides an affirmative defense. That affirmative defense works. It provides nursing homes and long care facilities with a complete defense. And if they follow the rules, they follow the public health directives, then there is no exposure, there is no liability, they win their case. It also provides senior residents in nursing homes with their rights. It provides them with their ability to seek a jury trial. It provides them with their ability to have a voice. It provides them with their ability to hold facilities accountable. It accommodates both worlds. It's not broken, it works. And I would hate to see us overreact and provide immunity when the system that is in place is accounting for both residents and it's accounting for both facilities.
Thank you very much. That's 4 minutes. Next, we will hear from Judy Belome of AARP Kansas, who I believe is also on WebEx. So please introduce yourself and welcome to committee.
Hi, can you hear me?
Yes.
Okay. Thank you, Madam Chairwoman, and members of the Senate Judiciary Committee. My name is Judy Belome, and I speak for AARP Kansas as their state volunteer president. As you can see in the papers in front of you, and in my written testimony, I'm an RN with years of experience in healthcare that includes adult care facilities, including PACE and Homes Plus, as well as home care and hospice. I served 12 years as an officer in the Navy Nurse Corps Reserve. Just want you to understand my credentials as a healthcare provider and administrator. AARP strongly opposes providing immunity from civil liability for COVID-19 claims for any and all adult care facilities. These facilities are different from hospital care, as was purported in the previous statement, in that many citizens and even their family members and are people with disabilities and frailties, they call these facilities their home. Even in an unexpected event, safety and quality of care must be ensured in your home. The amendments do not change the fact that these vulnerable residents and their families would not be receiving the security of knowing that the right care with competent and adequate staffing is guaranteed to be provided. These facilities are responsible and should be held accountable for appropriate care. Filing a lawsuit is a last resort, but still should be guaranteed. Think of a family member of your own family in their homes, residing in an adult care facility. Wouldn't you hold them to the highest standards? I'll stand for questions at the appropriate time.
Thank you. Next, we have Margaret Farley, Kansas Advocates for Better Care. Please introduce yourself and welcome to committee.
Thank you, Chair Warren and members of the Senate Committee on the Judiciary. My name is Margaret Farley. I am the sort of brand spanking new Executive Director of Kansas Advocates for Better Care. This is my second time in this job. I was involved with, as the Executive Director of Kansas Advocates for Better Care in the 90s. I have never seen so much exposed regarding the flaws and problems in nursing homes as we run them today ever. We have so many issues that have been exposed through COVID-19. It's going to take a while, frankly, to get to the bottom of it. I am saddened and disappointed that the way this is being framed, sometimes from the industry, is that this is a residence, facilities versus residence type issue. Whether or not these facilities are businesses in small communities that are large, we have to remember that the only reason that nursing facilities exist is to take care of the people who live in these facilities. We oppose House Bill 2126 because it takes away one of residents' last remaining rights in a time period, in a storm, whereby these people in the facilities were literally often abandoned. And I'm not saying that people intended to do that. They were not prepared for a pandemic, and a pandemic was predictable. And PPE, if people did not know about PPE before the pandemic, that's just an example of the problem that this industry is in. I urge you to read two articles that I've mentioned. One is another from the Associated Press, and it was titled "Not Just COVID, Nursing Home Neglect Deaths Surge in the Shadows," and it reported that for every 2 COVID-19 victims in long-term care, there is another person who died prematurely of other causes. This was a nightmare for so many, both residents and staff. But the solution should not be to ignore that situation and not let them have their day in court. In case
1 minute remaining.
Thank you, Chair. In case after case family members report the neglect that is appalling. I'm not going to talk about that incident here, but it's listed in our testimony. In addition to which, the March 13th New York Times article has just done an excellent study in great detail with first-rate documentation titled "Maggots, Rape, and Yet 5 Stars, How U.S. Ratings of Nursing Homes Mislead the Public." And part of the gist of that article is that nursing homes are able to game the 5-star situation. They do it intentionally, and they represent that their care is better. I'm not saying they all do that. That is an issue. Infection control was a recognized problem in nursing facilities, both in Kansas and across the nation prior to the pandemic. They have had notice. They have had the opportunity to correct and the opportunity to prepare. Now is the time for residents to have their day in court. Thank you, Madam Chair.
Thank you very much. Committee, we have in your committee folder opponent written testimony from Camille K. Russell, Office of the Kansas Long-Term Care Ombudsman. And with that, I will ask, are there any opponent conferees in the committee meeting room or on WebEx? Seeing one, then please introduce yourself and welcome to committee. 4 minutes.
Madam Chair, members of the committee, my name is Joseph Molina. You guys saw me a couple times. I've been here. I believe I submitted testimony earlier over the weekend. I represent the Kansas Bar Association, and we're here today to oppose this bill because of access to justice. We find that to be a very, very important part of the legal system. You've heard from some of the conferees about how this would help the nursing home facilities. But what you really haven't heard from anyone was how this would be detrimental to the individual. And we'd like you guys to take a closer look at that, because this is a policy decision on your part on what is the best balancing test. And for the KBA's point of view, among the options, providing an affirmative defense to adult care facilities is the best, most rational option. I understand that we're short on time, so I want to make this quick. Again, the Kansas Bar Association would like you to consider keeping the affirmative defense and not providing the added or extended immunity as sought through House Bill 2126. Thank you.
Thank you. Any other conferees in the committee meeting room or on WebEx? Seeing and hearing none, then, committee, we will open it up for questions for any of our conferees, proponents or opponents. So, yes, Senator Wilborn.
Thank you, Madam Chair. I would like to, for the record, set the record straight. The conferees indicated that we as a legislature made the choice of affirmative action versus immunity. It was the governor of Kansas who vetoed the immunity for rest homes, hospitals. And then when we brought the bill back, she would not agree to have that immunity provision put in. So this lays squarely on the governor's desk. Thank you.
Senator Haley.
Thank you, Madam Chair. First, Madam Chair, I need to ask if the chamber, this has its thumbprint all over it. Has the Kansas Chamber submitted any testimony as a proponent or opponent on this measure? I'm just surprised because it seems like something they have an interest in.
They have not submitted testimony to my knowledge, no.
Okay. Well, my question then, Madam Chair, probably is for the proponents. And I don't know who wants to weigh in on this. Of course, for me, and the concern I had in the previous bill, I think it was 283, is who Mr. Thompson said what the bill was, is how do we reconcile, and I'll be brief, Madam Chair, the question comes down to substantial compliance. And if that substantial compliance is clearly defined and outlined for ongoing care or ongoing protection of those inhabitants of our care facilities. I don't know that they've been clearly outlined. I don't know if the proponents, those who are advocates for this broad sweeping immunity, could weigh in as to the accountability issue for whether substantial compliance can be too easily met. I'm not framing the correct question, Madam Chair, but this is certainly where I'm wrestling with it, and I don't know. I see Mr. Maloney coming to the maybe he can assist me in framing it and helping to clear up my angst.
Madam Chair, this is Mark Maloney with the Hinkle Law Firm. Senator Haley, I believe I hear you asking, isn't the defense that the nursing home is in substantial compliance enough? And what I would argue is that's the case in every litigation matter involving health care. The issue here, to me, is really why is the nursing home, long-term care, assisted living facility group being treated differently than health care providers, hospitals, physicians, clinics? In every case I litigate, compliance with a guideline, an expert's testimony on standard of care becomes a litigated issue. This bill, I believe, attempts to correct what the governor did last spring in carving out the long-term care facility. I know I've pivoted a little bit away from your question directly, but that's, to me, when you say substantial compliance, that's what I deal with day to day in defending healthcare providers.
Thank you, Madam Chair, and thank you, Mr. Maloney. That is exactly what I was trying to frame, and you did it very well, Counselor. My question and concern is, unlike the other facilities, the adult care homes are the homes of the ongoing home for most of these residents. There is no alternative. They are captive, if you will, for lack of a better word.
They're residents.
Residents, long-term, and there's no option. And they have to have the strict and the highest, as far, at least as I'm concerned, level of care provided and substantially complying. And to waive if that has not been met, for me, is a test that concerns me because they have nowhere else to go. I mean, this is their only residence. Thank you, Madam Chair, and thank you.
Thank you. Other questions? Yes, Senator Baumgardner.
Madam Chair, and I actually have several questions. My first is for the opponents. Either of them can speak to this. So I think we're all in agreement that a long-term care facility is essentially the home for that Kansan. What home in Kansas during COVID was mandated to take someone that was COVID positive to reside there, other than a long-term home facility?
If we have an opponent conferee who can respond.
This is Tom Wagstaff, and I will, let me just try to make sure I understand the question first, if I could. When you ask what other home, are you talking about any home in general?
Yes, give me an example of a home, Madam Chair, other than a long-term care facility that was mandated by KDADS and KDHE to take a COVID positive resident.
Well, I can't tell you another regulated home right off the top of my head, just to be sincere to your question. I guess I would say that
that's enough. I've
fair
got the, so I guess that leads me to the four opponents that testified today. Where the heck were you guys with regard to these Kansas residents that are in long-term care facilities? Because we had two separate hearings specifically about the issue of the health and well-being of people in long-term care facilities. Where were you when KDADS and KDHE were telling us this summer that, don't worry, CMS doesn't require us until the end of July to make sure that we have completed disease control training? You know, we were shut down as a state in March. So for 5 months, we did not, through KDADS or KDHE, have that disease control training in our long-term care facilities. So where were you advocating for these folks then?
I'd like to answer that, if I may. Margaret Farley with Kansas Advocates for Better Care. I certainly do wish that residents had the authority that your question assumes that they had. We would like to be able to control what is happening in this situation, but we are not the parties that run these facilities, and facilities know how to do this. Of course, COVID was a storm that came in, and that is why it is important to have the facts laid out in individual actions and lawsuits, because you can assume one fact. It doesn't mean that you know all of the facts, and that is why Kansas Advocates for Better Care is very concerned that residents and their family members of the residents who died and who know nothing about what happened, that they have their day in court.
And I might,
Chair,
if I
guess
could
my
echo
question is, to be more clear, you know, we heard testimony from our secretary of KDHE that PPEs were stockpiled, and yet we knew that they had not been distributed to the long-term care facilities. We knew that hospitals have the highest level of education and training for their employees, and yet that is not true for long-term care facilities. And yet we knew in April, in May, and in June that KDHE and KDADS had not provided or required local health officials to go and visit the long-term care facilities and to make sure that they had appropriate PPEs or that they had the ongoing training for specific COVID infection disease control training. So when KDHE and KDADS take a position that long-term care facilities play the critical role in healthcare systems in Kansas, and yet do not provide them with PPEs, instead stockpile them for hospitals, it's very disingenuous that they are just left standing. And no, we did not hear testimony from AARP or from the Bar Association or from the trial attorneys or for Kansas Advocates for Better Care demanding that the stockpiles be released and provided to long-term care facilities, or that the training was completed prior to the July 1st deadline that was set by CMS. So it rings hollow when we know that we're talking about more than 20,000 beds that are homes for Kansans in long-term care facilities, and yet we know the individuals that work there are the lowest paid. They are CNAs for the most part, where they earn an average of $10 to $13 per hour. We know there's constant turnover of that workforce. And it's interesting that we're concerned about keeping the accountability piece, making sure there's accountability, but the only accountability we're hearing about is litigation, not the accountability for the Department of Health, not the accountability for KDADS, not the accountability even for CMS. So I guess I would just wonder again, why were these demands not being made by the Bar Association, by Kansas Advocates for Better Care, of these agencies who are responsible for the oversight of these facilities?
Senator, I'm pretty
Thank
sure
you.
that Kansas Advocates was asking the Department
Please
of Health
identify
and
yourself.
Environment about these. Sorry, again, Margaret Farley with Kansas Advocates for Better Care. I cannot sit here and say that we did not ask for that. Big part of what we do is to work with KDHE, KDADS around issues relating to visitation, aid training, all of these things. And so I can't say that we didn't. I will point out, Senator, to the issues that you raised. The first question is how many of the corporations that are national and statewide corporations that run these facilities. It's not just the individual facility. These corporations run these facilities. And while people like to talk about the negative effect on the facilities and the staff, I am sorry for the things that have happened during COVID that have so beat down staff and nursing facilities. But that is not the fault of the residents. And many, if not most of these corporations have big money and financial investment behind them. And it's not just the administrator or the DON who are sitting outside KDADS begging for masks. They are operated by big corporations that have lots of resources. So I'm sorry, but I'm offended by these questions.
Thank you. Other questions?
Yeah,
Senator Baumgartner.
Just as a follow-up, I'm sorry if you're offended by these questions, but I remember your testimony this summer, and it was not very much in support of, in fact, it was to make sure that long-term care facilities would not have any type of protections. It was not urging for any of the PPEs that were stockpiled to be transferred to these facilities. I think it's important that we ask these questions because, quite frankly, my argument in the summer is the same as it is today. Why is it that these groups are willing to not require, to not mandate the same standards for hospitals as far as holding hospitals accountable in the same way that our nursing homes are being left without any legal cover? And what it's all boiled down to is, again, what our vice chair had to say. Long-term care facilities were carved out by our governor, and yet we know that long-term facilities in printed documents were required to take COVID patients. They were required to take COVID positive patients when KDHE and KDADS knew that they did not have the appropriate trained personnel or any of the appropriate required quantities of PPEs. And when we talk about big companies, large corporations, and in one swath we attack them, I do want to remind those that are listening and attending today that it's been those big corporations, those box stores, we call them Walmart, CVS, etc., and they're the ones that have come forward and have done the COVID testing for us when our physicians haven't done that, when our hospitals haven't done that. They're the ones that have stepped forward to get into long care facilities to make sure those people receive vaccinations. And they, quite frankly, are going to be the ones that make sure that as we step into phase 3 and 4, vaccinations are distributed throughout the state. So I'm very hesitant to attack large corporations because the fact of the matter is we're going to be very dependent on them as Kansans to claw ourselves out of this COVID pandemic. Thank you, Madam Chair.
Thank you, Senator. Senator Corson.
Thank you, Madam Chair. I have a question, I think probably for Mr. Maloney. And my question is this, we just heard and worked on the KEMA bill, and as a committee we spent days working on that bill, and then I was privileged to be on the conference committee, and we spent almost a week working on that bill. And one of the things that was really important to every single member of this committee, and I believe every single member of the Senate, and I know it was a focus of our work in the conference committee, was making sure that aggrieved parties had an ability to seek redress. And so we really put a lot of time into, and we were very prescriptive in how we did it as far as what the timeline would be, what the standard of review was, what the appeal procedures were. For every single Kansan, essentially, if you felt like you were aggrieved by an order from issued by the governor, if you felt like you were aggrieved from an order issued by a municipality, by a school district, by a community college board, because this committee felt like it was so important that individuals have the ability to have access to the courts and to seek redress when they believe that they've been aggrieved. And so I'm just having trouble understanding why the committee should reverse its position and then say that in this instance, in this one instance, aggrieved parties should not be able to seek redress only when it applies to these nursing home and long-term care facilities. Thank you.
Before you respond, I'm going to clear up something for those listening online. The committee doesn't have a position on this yet, so for a committee member to state that it does is not accurate. We are hearing this bill today, HB 2126, so I want to clear that up, that that was part of the premise of the question, and that's not accurate. But go ahead and respond. Thank you.
Madam Chair, this is Mark Maloney with the Hinkle Law Firm again. Senator Corson, I'm not exactly sure I've followed your question, and I apologize.
Well, let me just ask it much more straightforward. In the KEMA bill, we were very expressed. We wanted to make sure that individuals had an ability to seek redress, right? And that bill, that was a very important part of our committee's work and our committee's discussions. Many members on this committee expressed that that was a priority as far as something that they wanted to make sure that that was very clearly stated, that there was a clear timeline, there was a clear standard of review, there was a clear appeals process where if a person felt like they were aggrieved, they could seek redress. So it seems to me like this bill is taking the opposite position and saying individuals should not be able to seek redress. And I'm having trouble squaring that circle and understanding why it made sense in that instance, but it doesn't make sense only when it applies to nursing homes.
If you can, Senator, I mean, this proponent wasn't part of that committee and wouldn't have a position on a different bill and wasn't a proponent of for a different bill. So I guess if you can respond, but it seems to me we need to keep to the subject matter at hand, which is HB 2126.
Madam Chair, thank you, and you're exactly right. I'm unfamiliar with the other legislation you're referencing.
Go ahead and introduce yourself, though.
Sorry, I'm Mark Maloney with the Hinkle Law Firm. Again, Senator Corson, a little bit in over my head here in terms of the other legislation and how you're trying to square the two bills. I would simply say that for my clients and the group I represent, they take this legislation and they look at what happened last spring. And to my group of constituents, they say, why were other healthcare providers treated better than we were when we are literally kind of the bottom rung of healthcare in terms of education, training, pay? We're boots on the ground. We're 24/7 because Senator Haley's right. This is those residents' homes. These folks rely on our aides and our nurses and our LPNs 24/7. So my group looks at the bill that was passed that became law during a special session, and they scratch their head and they say, why were we treated differently? I know that doesn't address your question specifically, and I apologize, but I'm unfamiliar with the other legislation.
Can I ask one quick one, Madam Chair? I just want to get this answer in the record. My understanding, and so please correct me, is that there are only 2 or 3 active cases. It sounds like you have a couple of them that are these COVID-19 related claims. Is that correct? And if so, are you worried about a raft of yet to be filed lawsuits? Because it seems like a lot to ask us to be involved if there's only 2 or 3 cases that are working their way through the court. So can you just please speak to that for the record? Thank you. And thank you, Madam Chair.
Madam Chair, again, Mark Maloney with the Hinkle Law Firm. Senator Corson, to the best of my knowledge, you're correct. There are 3, I'll call them separate groups of cases. I'm handling one group in South Central Kansas in Sedgwick County District Court. My colleague BK Christopher in the Metro Kansas City area is handling 2 additional groups of cases. I believe they're now in Wyandotte County District Court. They were originally removed to federal court, and I think they've been remanded. And so you're right, there is a limited number. What I would say in response to your question about am I concerned about a wave of cases, I would say that the environment is ripe for that wave. And I would point to about 3 ingredients that make me say that. First, Mr. Wagstaff and the KTLA and the, quote, plaintiff's bar, close quote, are incredibly astute counsel and business people. They'll analyze and they'll wait and see what level of success they can have. They don't just dive in. They're very calculating. They've also been able to enjoy Chief Justice Lukert's stay of the statute of limitations, so that will extend the time frame within which they can file. Secondly, these types of cases will become more and more attractive to that very capable plaintiff's bar in light of the Supreme Court's ruling in Hilburn, where the pain and suffering cap was struck down. So when you combine those different elements, I do fear that there is a group of plaintiffs' attorneys, very capable, very astute, waiting in the wings, waiting to see what comes of this type of legislation, and is there money to be made pursuing these claims? Thank you.
Thank you. Committee, we do now have more than 5 minutes over our allotted time. So with that, I am going to close the hearing on House Bill 2126 and turn to back to House Bill 2227 with the committee's indulgence and see if we can work House Bill 2227. If there are any amendments, we can hold off on working it, but it's a bill that's akin to, has some similarities to speedy trial issues, but we do have the March 31st, 2021 deadline coming up, so I want to see if we can work House Bill 2227 today as well. So we will open up working House Bill 2227 and open it up for discussion. Any discussion on the bill? Senator Gossage.
Yes, Madam Chair, I move that we pass House Bill 2227 favorably out of committee.
A second from Senator Haley. Thank you. Committee, any discussion on the motion? Seeing none, you all have heard the motion. All those in favor, aye. All those opposed, nay. The motion passes. And just to make sure we were, the motion was for House Bill 2126 as amended. I'm sorry, got the wrong one in front of me. So 2227 as amended, correct? And Mr. Reviser, are we good with that?
Thank you, Madam Chair. Jason Thompson with the reviser. Not as amended by you, but as amended by the House committee. Yes, it's just a motion to be passed by your committee.
Yes, as amended by the House. Okay, then the motion passes. And thank you, committee, for your time and those